May it please your Lordship, I am Yate-McLeod, and I appear for the appellant in this action. My learned junior is Ibrahim Yate. As I have been informed that your Lordship is already familiar with the facts of this case, I will now proceed with my submissions. Mr. Cameron has been charged with dishonestly obtaining an electronic communication service in violation of Section 125, subsection 1 of the Communications Act 2003. It is my submission that your Lordship should overturn this decision by District Judge Brown on the grounds that Mr. Cameron did not have the necessary mens rea to commit this offence, and that his actions could not be considered by a reasonable person to have been dishonest. I make this submission based on three grounds. Firstly, that when compared with other instances where dishonesty has been proven in relation to the Communications Act, the locus in quo supports Mr. Cameron's claim that he was acting without dishonest intent. Furthermore, that the lack of password protection on Mr. Clegg's account shows that Mr. Cameron's claim that he was connecting to it by an honest mistake seems perfectly plausible. And finally, that his lack of suspicious activity whilst connected to Mr. Clegg's account shows a lack of malicious intent. On the first point, in previous convictions related to this offence, the place from which the accused attempted to connect to another's network suggests dishonest intent. I would like to cite here the case of Gregory Straskiewicz from London Ealing 2005, which is on page 3 of the bundle provided. Being a case of first instance, there was no law report for this case. However, I will now provide a brief summary for your Lordship's benefit. In 2005, Gregory Straskiewicz was seen in the London Ealing area attempting to access Wi-Fi from his laptop in his car in the middle of the street. He was reported by neighbours as acting suspiciously and was arrested and charged under Section 125 of the Communications Act for dishonestly obtaining an electronic communications service. Now, being in his car, it's reasonable to say that Mr. Straskiewicz knew perfectly well that the account he would be connecting to was not his own. This shows dishonesty in his action, and thus Section 125 is perfectly applicable. However, by contrast, the location in which Mr. Cameron was attempting to connect was his front garden, and it is perfectly reasonable for him to assume in that location that he would be connecting his own network. Thus, the locus in quo suggests that when he said he had no knowledge that he was not connecting to his own network, it suggests it's perfectly plausible. Moreover, Cameron stated that his connection to Clegg's network was accidental, a result of his laptop automatically connecting to the strongest available network. At Mr. Cameron's trial, it was discovered that Mr. Clegg's network had not been password protected, and thus, when Mr. Cameron's laptop connected to it, there was no demand for a password or any additional information which would make Mr. Cameron aware that the account was not his own. I wish to refer your Lordship's attention here to the article Law in the Last Mile, Sharing Internet Access Through Wi-Fi by Yate-McLeod, which specifically is on page 6 of the bundle. McLeod provides a helpful definition of what may be considered dishonestly obtaining a service. He specifies that an act is necessary for dishonesty to be proved, that one needs to show that there is a deliberate attempt to circumvent an obstacle, showing that one knows exactly what one is doing and is acting dishonestly. He provides the example of a person climbing over the walls at a football match to attempt to view the game without paying the entrance fee. Now, Cameron's situation contrasts this example. His actions show no deliberate attempt to avoid payment, and no act which would show knowledge of what he was doing was dishonest. This shows that he was indeed acting with an honest mind. Finally, I submit that the lack of suspicious activity on Cameron's part speaks to his innocence. At the trial, it was proved that he had never in the past attempted to access Mr. Clegg's computer or use his connection for any illicit service. I submit that it is unreasonable to assume that he would deliberately and dishonestly attempt to connect to someone else's network for the innocuous task of checking emails in his garden. Unless I am able to provide further assistance to your Lordship, I will now defer to my learned junior, Ibrahim Yate.
If it may please your Lordship, I am Ibrahim Yate, and I will continue the case for the appellant. My Lord, I submit that Cameron was not intending to avoid payment for the service he received for the following 4 reasons. Firstly, because Mr. Cameron paid a flat rate using another person's network, this would not benefit him financially and would give him no real motivation to avoid payment. Secondly, my Lord, the flat rate itself made it impossible to benefit financially from using Clegg's service in particular, so this misuse of networks victimizes no party involved in this affair. Thirdly, it is possible that Cameron only began accidentally using Clegg's network once Clegg installed a stronger router in the year 2008. And fourthly, my Lord, Cameron's frequent use of his laptop in his garden suggests that he did not notice the change in the SSID username, through perhaps sheer force of habit, especially as he had no financial motivation to deliberately ignore it. I shall now proceed to explain these 4 arguments for appealing the case at hand. Since Cameron was paying a flat rate for his network connection, using another person's network would indeed not reduce the rate he himself had to pay. Cameron therefore had insufficient reason to try and avoid payment. If he was motivated to avoid payment by piggybacking on Clegg's Wi-Fi, it would have made more financial sense to discontinue his own subscription, and this he did not do. Because Cameron is paying a flat rate, the nature of the service provided makes it impossible for Cameron to avoid payment. Cameron cannot therefore be seen as avoiding payment through the use of Clegg's internet service provider, as he is not incurring any more charges on Clegg. This is because it would be unreasonable for the internet service provider to assume that only one person will use their uncapped service. By way of comparison, my Lord, I cite Yate-McLeod in the article previously cited by my learned senior. McLeod argues, and I quote, at the bottom of page 4 in the bundle, underlined, that a user with a subscription to a telephone service would presumably be forbidden from allowing others to use unlimited calling plans, as the making of calls by others would be an illegal deprivation of revenue. This is indeed absurd, my Lord, but is it any more absurd than charging users of open networks, I ask? Thirdly, my Lord, the nature of the evidence given is vague in itself, and provides more plausible grounds for suggesting that Cameron did indeed not use Clegg's internet connection to evade payment. For example, when Cameron's computer was forcibly examined by the police, it was found that he had used Clegg's internet, and I quote, numerous times in the past. This statement, however, gives no indication of how far back in the past Cameron used Clegg's network. Indeed, because wireless routers automatically connect to the strongest network available within the immediate vicinity, it is plausible that once Clegg brought his new router from cable Vinsk online, Cameron's wireless card automatically began connecting to Clegg's in the year 2008. I therefore submit, my Lord, that Cameron's wireless card automatically switched to Clegg's network, indicating that before 2008 it is indeed possible and very plausible that Cameron was using his own network, which further speaks to his innocence. And finally, my Lord, because Cameron stated that he frequently uses his laptop in the garden to send and receive emails, it is plausible that, through sheer force of habit, he did not pay attention to any changes in network connection indicated through the change in the SSID. This is because a person who habitually uses a laptop does not necessarily go and read every pop-up window that appears on his screen. It is not therefore unreasonable to assume that Cameron did not notice the change in the SSID username, especially as he had no real financial motivation to avoid the payment as previously stated. In summary then, my Lord, it appears that Cameron did indeed have no real financial reason to avoid payment for his own services, and that his use of Clegg's network was more likely to be accidental than deliberate. And unless I can provide further assistance to your Lordship, Those are the arguments with which I would like to conclude the case for the appellant. Thank you.